Welcome to Ground Rules, employment law over your coffee break. My name is Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath, who you'll be hearing from shortly. And we wanted to tell you a little bit about who we are and why we decided to launch this podcast, because this is our very first edition of Ground Rules. So we work for Idaho employment lawyers, and we help employers with the full gamut of compliance issues that supervisors, business owners, and HR professionals encounter as they try to run a business. So we help employers with counseling to avoid problems, workplace investigations, training, and we do litigation and claims defense too. And that is really what started the concept of ground rules, is our role as litigators and seeing firsthand just how miserable it is for clients when they're caught in a lawsuit and when they're hauled into court. So although when you're watching TV shows like Suits and like The Lincoln Lawyer, which I just watched the most recent season, it looks like fun and it seems glamorous, but the reality is if you're an employer and you get hauled into court, it's pretty miserable. It's expensive, it's stressful, and it's very uncertain and hard to control. That is the reality of litigation, and we want to tell you a little bit more about that. The other thing that we've seen over time is that if you're an employer and if you take some basic measures to learn some key foundational concepts and to stay on top of the law, then you can avoid claims and lawsuits. In fact, what we see is it's really the same issues over and over again that cause employers to get hauled into court. That's what we want to help with. We want to help you know and understand key employment law concepts so that you can spot issues and flag them before it's too late, before you've already created liability by something that you've done. So we want to make sure that you know the ground rules, and that's what we're here to talk about today. So I'm going to turn this over to Jennifer Walrath first. She's a seasoned litigator, and I'm going to ask you to share a little bit about why you wanted to do the podcast and what you think it's important for employers to know.
Yeah. Well, hello, everyone. Welcome. I feel like Pam sort of stole my thunder a little bit, but, before I should say my first 10 years of my profession, I worked with a lot of, very large employers and frequently saw litigation or even investigations for compliance-related issues where clients were spending hundreds of thousands, even, $1 million+ defending or paying attorneys to help them work through the investigation process. And what I've really learned in recent years and kind of taken away is that the impact isn't really any different for a smaller company, right? The litigation costs are still going to be there. And not only the dollars out the door, but business disruption, employee time, when you're preparing people for depositions. I mean, we're going to sit here and say, hey, block out a day, at least, for each employee who's getting posed to work with them. And then they're actually going to have a day where they're sitting and kind of under the glaring light bulb, getting asked questions and put on the spot, which is never comfortable for anyone. And we're going to be asking you for all kinds of documents and asking you questions and having you review things. So in addition to the money out the door, there really is the time component as well, and just sort of the disruption to the business that happens. And at the end of the day, if you're in litigation, the results are kind of uncertain. I mean, you have a little more control when you're in front of a judge because it's a little more based on the law. But if you get in front of a jury, it's a little bit unpredictable. I mean, juries just don't necessarily follow the law. They go by what their gut feeling is and what they feel is fair or not fair. And we have seen some verdicts here in Idaho in the last, 3 years?
5 years.
5 years.
Mm-hmm.
Even things like emotional distress damages, right? Kind of being in the hundreds of thousands of dollars, some verdicts over $1 million in total. These are employment law cases. So just kind of another weight on the scale of trying to address these issues earlier is that there have been some employers here who have seen some unfavorable verdicts coming out of jury trials. And I would say out of the different cases that we got the statistics for, out of maybe a dozen or something, I mean, the majority were plaintiff side former employee verdicts. So it wasn't all that great for employers doing well in front of juries, I would say, at least in the most recent years here in Idaho. So for myself, I've drunk the Kool-Aid and I've bought into, and I think it makes sense, right? For employers, like knowledge is power. So the more you know, the better you can try to spot issues, address them, not only, in a way that complies with the law, but that also shows your employees that you care, you take their issues seriously, you're being fair, even-handed in how you're handling things. Of course, some things you have to do to be compliant with the law don't come across as being fair. But at the end of the day, more often than not, if you can explain why you're doing what you're doing, for a lot of employees, that makes a big difference. If they can see that, you're walking them through the process, you're working with them, that can really help to avoid angering employees, which often is a driver behind someone bringing a claim. So all to say, really kind of understanding the law enough to be able to spot those issues and to identify when something needs to be kind of elevated and addressed on a more compliance-based approach and not just a people-based approach is kind of where we come in.
Yeah, that's a big deal. And we have some new information, some new statistics that Jennifer mentioned that we've never really had before. And I think it's fascinating that when you see the data that's been compiled by one law firm here locally, it's the first time we've ever really had 5 years of employment law data compiled in one place. I'm curious, I'm guessing Doug's got some thoughts on that too. Yeah. And I don't want to steal all of Doug's content either. So we'll circle back on that and we'll see if there's anything else that we want to point out to you. But it really does show that over a 5-year period, a couple of things that we already knew, like not that many cases go to trial. I think over that 5-year period, there was 10 or 12 cases across the whole state of Idaho in the employment law arena that went to trial. But a few other very valuable takeaways that we want to make sure that you know and understand, because it really does underscore just how dangerous litigation can be. So, Doug, tell us a little bit about yourself and, if there are other things that jumped out at you from that data, let's talk about that.
Yeah, absolutely. So I'm Doug Plass. I've only been an attorney for a few years now. I came to the law a little later in life. But that meant I spent some more time out in the world. So I actually was a chef and restaurant owner. So I'm used to being an employer and having employees and all kind of the issues having to do with that. I came to the law to try to get things done and solve problems. And that's why I'm here. And that's why I'm taking part in this podcast, is because it's an opportunity to do that and get ahead of things before they become really big problems. So, yeah. So as to the data here in Idaho about jury verdicts. So I didn't have the data on this, but my understanding is like something like only between 2 to 5% of all civil cases go to trial. So if we got 10 verdicts in 5 years, that means there probably were a couple of hundred that were settled earlier on or disposed of in some other way. And among those 10 verdicts that we looked at, we had 2 defense verdicts, so 2 cases where it went to trial and the employer prevailed and there was no judgment awarded to the employee. But then the other 8 all provided money and a verdict for the employee. And of those, 4 of them were over $1.5 million. One of them was nearly $4 million. One of them had a punitive damage amount of $1 million added to an award. So a jury said, you've totaled all your damages and we're going to give you another $1 million. So that's pretty astounding. And then the other 4 verdicts were between $80,000 and almost $700,000. So I thought that was really interesting. It seems like if you get to trial, you expect to spend $1 million. It's kind of where we're at.
Yeah.
Fees. Plus fees.
Yeah.
Yeah. And if you get to trial, it's going to take a while to get there and your fees are going to be long. So one thing I looked at in this data was the amount of time that it came to get to a resolution. So we had one case that was about a year and a half.
And so that's a year and a half from when the lawsuit was filed to when the verdict came in.
Right. Yeah. So you expect the conduct had probably started before that, especially if there were some administrative processes that needed to be exhausted. And then we had a couple more that were in the 2-year range. Looks like about 4 or 5 in the 3 to 4 year range. And then one case that took 8 years to get resolved and resulted in a $1.8 million for the plaintiff. So think about that for your business. Think about, 2 to 5 plus years being tied up with litigation, having to continually deal with it, having to continually deal with people like us, asking you for more information and trying to figure out how to defend your case. And then you end up, after all is said and done, writing a very big check and maybe having it destroy your business altogether. So we want to help avoid that. We want to get in there on the front end because we found that employers, by and large, are trying to do the right thing. They're not out to get their employees. They're not out to discriminate against their employees or retaliate against them. They just need the tools in order to do it right. And that's what we're trying to do.
Yep. And I think a couple of things are worth talking about when it comes to that timing issue, because I've been a litigator for almost 25 years now here in Idaho. And one thing that I've observed is that after COVID, maybe about the time that COVID started, it greatly impacted our courts. So one thing that I think a lot of people don't understand is that if you have a lawsuit brought against you, it's difficult to get in front of the judge. Like, we, as your lawyers, don't have a lot of control as to when the court will hear your case. If you have motions you want to bring to try to get it resolved, we don't have a lot of control over how quickly that will happen. And all of that results in a situation where your case may well last, like Doug said, 2 years, 3 years, 4 years, even if the case doesn't have a lot of merit. I think a lot of times we get calls from clients who are like, yeah, the case is bogus. We didn't do anything wrong. We want you just to make it go away. But that's not really how our judicial system is set up. And it's a very rare set of facts that would allow us to get the case dismissed right out of the gate. Instead, the whole judicial system is set up so that both sides get to present their facts after you've gone through a full and complete discovery period, which frequently spans, a year, 2 years, just that part of the process alone. So this law firm was started in 2016, and the year after that, we had a couple cases come in the door. One of those cases is still on appeal to the Ninth Circuit. I mean, just to give you an example, yes, a lot of cases take 2 to 3 years to resolve. Some take 6 years, 7 years, 8 years. And that is definitely something you want to avoid because, like Jennifer and Doug both said, it's a productivity, total sap your productivity. It's stressful. For some reason, employment law cases are highly charged. It's emotional. Someone's lost their employment, their ability to provide for their family, maybe. I mean, the allegations against the employer are almost always that they've done something wrong. They've broken the law. They lack integrity. They lack credibility. They're bad people. All of that makes employment litigation very contentious and very unpleasant to go through, even if you think you haven't done anything wrong. Trust us when we say you want to avoid litigation altogether. And that's really what we're doing here is we want to provide resources for business owners, supervisors, HR professionals, anyone who really has to apply compliance law issues in their day-to-day. one thing we haven't talked about is that another common problem we see all the time is that supervisors do not typically get the training they need on basic compliance issues. So a lot of employers don't understand that if you're a supervisor, the law holds you to a higher standard, and the law presumes that you're getting the training you need to know and understand compliance law basics. What we see instead is that a lot of times, for obvious reasons, employers hire supervisors based on industry experience or industry expertise, but somehow those supervisors are not getting the compliance law training they need in order to do basic issue spotting, because that's what this is really all about. We're not expecting you to get a bar license or to, go through law school. You don't need to do that, but you do need to be able to spot employment law issues so you can get help before a problem arises. And we fully recognize that in your day-to-day, you have so much on your plate, it may be difficult for you to get access to a resource that can help you do that. So that's what this podcast is all about. We recognize that employment law is constantly changing. We're going to talk about that in our next episode, and maybe highlight a little bit about what you can anticipate in 2025. But part of the reason we all like employment law is because it changes. The new administration could have changes. Changing social norms could result in changes. That makes it fun for us, but more difficult for you to stay on top of what you need to know. And so that's what Ground Rules is really all about. We want to give you the ground rules to know and understand employment law just enough so you can spot issues before it's too late to comply with the law. So we're hoping to see you at our next episode. It's going to explore, hopefully, our view on what you may or may not expect in 2025 when it comes to employment law changes. And in the meantime, if you want to, follow us on LinkedIn, check out our email blast, because we're trying to keep everyone as updated as possible on issues as they change. And those are other tools that can help you get there. We also have a book that we just released that's about to be available, and that tracks these key fundamental employment law issues that everyone needs to know too. So thanks again for learning the ground rules of employment law over your coffee break, and we'll see you at our next episode.